Hi, Wes Scott from Life Back Law. Today we're going to talk to you Minnesota family law lawyers. And this article is titled 3 Things Every Minnesota Family Law Lawyer Should Know About Bankruptcy. And the first thing we're going to talk about is a topic that is happening right now. And so, if you're a family law lawyer, divorce lawyer, this is something you gotta pay attention to. Number one, if you represent somebody in a divorce who's been awarded property, titled property, like a home, car, things like that, you gotta make sure they perfect their interest in that property immediately by either, for example, if they're awarded a home, file the certified copy of the divorce decree with the recorder's office immediately, or, of course, the deed. What we're seeing in bankruptcies, Chapter 7 in particular, is Chapter 7 trustees going after ex-spouses in divorce cases where they did not record their interest with the county, claiming, well, then the estate owns it. There's no public record of you owning this property. So now it becomes an asset of the bankruptcy estate. You don't want to do this. Your clients are not going to find this funny. So if you have a client who's awarded a vehicle, transfer the title right away. If you have a client who's awarded real estate, the home, record it right away. Number 2, remember that debts the ex-spouse agreed to pay in the divorce is not dischargeable as to your client. So if your client successfully has the ex pay the $20,000 credit card, joint credit card, that's wonderful. And if the ex files a Chapter 7 bankruptcy, their liability to your client does not go away. In other words, that hold harmless clause does not go away. It survives the bankruptcy. So as between the ex-spouse and the credit card company, their liability for the debt goes away. But the ex-spouse's liability to your client survives the bankruptcy, so that if your client ends up having to pay because the ex-spouse didn't, then they can pursue the ex-spouse. Now, of course, that still means that the ex-spouse can toy with your client's credit. And so the best is not to, is to finish the divorce with no, obviously, joint debt. That's the best idea. Third, remember that child support and alimony is not dischargeable in a bankruptcy. Nobody has to bring an action to declare this to be true. And that includes anything state law considers child support, like medical bills. If state law says a child's medical bills are considered child support, then the ex-spouse's liability on those medical bills also survives the bankruptcy with respect to your client. So as between the ex-spouse and the Mayo Clinic, their liability is gone. But as between your client and the ex-spouse, their liability for that debt remains. So when you're ready, if you have clients who need to file bankruptcy, if you've got questions about bankruptcy, feel free to reach out to Life Back Law. Thanks for listening.